So hello everyone, and welcome. Thank you very much for being here. Welcome to the panel on the Supreme Court and the right of inclusion after Moore. Is Canadian human rights law as inclusive as it should be? My name is Philippe Dufresne. I'm with the Canadian Human Rights Commission, and I will be chairing this panel of experts in what will be, I'm sure, a very fascinating discussion on cutting-edge human rights issues of the day. I want to thank the University of Ottawa's Human Rights Research and Education Centre for the support in presenting and preparing this panel, as well as the University of Ottawa Disability Law Association and Professor Ravi Malhotra for your support and assistance in the logistics. And again, we very much look forward to this. The Canadian Human Rights Commission is deeply committed to the advancement of human rights law in Canada. It's involved in the policy development, it's involved in protection of human rights, and it was involved in some of the major cases that will be discussed. And there's more work to be done. I want to introduce our panelists for today. To my right, we have Shelagh. She's an expert in human rights law, many years of experience working with government, non-governmental organizations. She was the director of the Saskatchewan Human Rights Commission, first president of the Women's Legal Education and Action Fund, and founder of the Court Challenges Program of Canada. Since 1984, she's been the senior editor and president of the Canadian Human Rights Reporter. For a number of us, this was our first introduction to human rights and human rights case law, so thank you, Shelagh. Director of the Poverty and Human Rights Centre and chair of the Human Rights Committee of the Canadian Feminist Alliance for International Action. She's worked internationally, she's commented internationally before United Nations bodies on Canada's compliance with its international human rights obligation. She's the co-author of 2 books and numerous articles on constitutional equality rights, and was awarded in 2008 the Governor General's Medal in commemoration of the Persons case for her contribution to the advancement of the rights of women in Canada. So she's certainly well placed to talk about human rights today and the current challenges. To my left, immediate left, we have Yvonne Peters, who practices human rights law, providing advice to individuals, unions, community groups, corporate sector, and government. She's a leading Canadian expert on disability rights, an author of research reports and articles in this field. She is the vice chair of the Manitoba Human Rights Commission and acts as in-house counsel to the Council of Canadians with Disabilities, and is the former chair of its Human Rights Committee. So again, significant current practical experience in human rights cases, and I've had the privilege of working with Yvonne Peters, and know that you'll have some very insightful comments from her today. Further to my left, Gwen Brodsky, who practices human rights law, teaches in the area of human rights law, constitutional law. She's director of the Poverty and Human Rights Centre, has written extensively about equality rights and has argued equality rights cases before tribunals and courts, including the Supreme Court of Canada, in some of the major cases that you'll be hearing about today. Andrews, Mossop, Mayorin, Vriend, Gosselin, and more recently, the Moore case. So very much we'll be hearing from someone who was directly involved in those fundamental human rights developments. And to the opposite right, we have Professor Ravi Malhotra, who joined the Faculty of Law here at University of Ottawa in 2006, obtained an LLM from Harvard in 2002, and completed his SJD at U of T in 2007 on the issue of the implications of globalization for labor law in the context of workers with disabilities. So his primary research interests are in the areas of labor and employment law, human rights, globalizations, and disability rights law. He has had experience working with a major human rights law firm in Ottawa, and has published widely in a number of journals. He has been very much interested in the issues of human rights, cutting-edge issues, in particular the issue of accessibility for persons with disabilities. And will be talking to us today about the Moore case and its implication. And so what we have planned today is is a discussion, panel discussion on those issues. But to set the stage, we wanted to have first an introduction of two very interesting and important elements to this debate. First is a paper by the CCD, Council for Canadians with Disabilities, entitled Accommodation in the 21st Century. That was authored by Gwen Brodsky, Shelagh, and Yvonne Peters, all three of which are here, and which sets out some of the challenges in case law after Mioran and Grismer. And so that will be the first discussion. Shelagh will introduce and summarize that report. It will be followed by discussion by Professor Malhotra on the Moore case, and then we'll open it up for discussion amongst the panelists, followed by a period of question with all of you. So without further ado, Shelagh.
Thank you very much. So I think my job this morning is to very, very quickly tell you how we got to today in the jurisprudence about the duty to accommodate in particular. This is quite a long journey, something that Gwen and Yvonne and I have been working on probably for as long as we've been involved in the human rights field. So it's a very long road that we're walking. But I want to start by setting the stage for this with the Mioran case, which came in 1999 from the Supreme Court of Canada. And it's the sort of backdrop to what Moore means today and how we got from one to the other. So you'll remember Tawny Mioran was a forest firefighter in British Columbia, and she lost her job because the British Columbia government introduced a new fitness standard. And the aerobic fitness standard was that you had to be able to run 2.5 kilometers in 11 minutes. And Tawny, who had been working as a forest firefighter for some years in British Columbia, very successfully, very strong, very fit woman, ran 2.5 kilometers in 11 minutes and 49 seconds and lost her job. The employer claimed that this was not discriminatory. The aerobic standard was neutral on its face. It was applied to men and women equally. It was done by individual testing, and consequently, there was no discrimination. Now, of course, Tawny Mioran was not unusual because the standard actually excluded women disproportionately because men's aerobic capacity and women's aerobic capacity are actually different. And so the standard had an adverse effect. At the time, however, the law was such that the remedies for overt discrimination and adverse effects discrimination were different. So the law was bifurcated. If it was a case of overt discrimination, the rule could be struck down because it was discriminatory. But if it was a case of adverse effect discrimination, as this was, you didn't strike down the rule. What you did was accommodate the person or try to accommodate the person or the group unless there was undue hardship. So we had a completely bifurcated case law. When Mioran came along, it was clear that that bifurcated analysis didn't work here at all. And consequently, we at the time went to our desks and scribbled and tried to persuade the court that in fact the moment had come to bring these two kinds of discrimination and the analyses of them and the remedies, therefore, together. And the court actually did that in Mioran. So we saw that as a huge change in the law. It did a number of things that were really important. For one thing, it made it a requirement in every case, no matter what the form of discrimination was, for an employer to show that they could not accommodate, they could not change the rule without undue hardship. So no matter what form, whether it was overt discrimination or adverse effect discrimination, that was the requirement. It did three very important things in our view. First of all, for the first time, adverse effect discrimination got treated as though it was just as important as overt discrimination. Second of all, the court recognized in Mioran that there could be discrimination embedded in a standard, and that if in fact you didn't examine, scrutinize, or strike down that standard, you were essentially leaving systemic discrimination in place and barring scrutiny of it. And the third thing it did was it made it very clear that the duty to accommodate is not accommodating the ones who are different on the margins. It's actually changing the rules or practices, the design of institutions, so that in fact groups previously excluded can be included. So it changed the whole sort of sense of what accommodation means. No surprise to us, I suppose. After Marin, what we saw, and this is what our paper actually has documented, is that there was a pushback from respondents. So when we made the duty to accommodate bigger and a harder thing to get through, it was much more difficult for an employer or a service provider to show that they couldn't change a rule without undue hardship. So when that became more difficult, the pushback was on the front part of the analysis. So the pushback becomes to complicate the test for discrimination, to try to make it more difficult for complainants to actually get to the duty to accommodate stage. And we saw that happen in 3 different ways. So there are 3 knots that then start to get all tangled up again. We were so happy with Marin because we thought it sort of sliced through the knots that were in the jurisprudence at the time. Then we see it get all tangled up again, and that's essentially what we've been struggling with. So there were 3 things that happened after Marin that tangled up the jurisprudence again. 1, there was a push to require comparator group analysis and to restrict the comparisons that can be made. Second, there was a push to narrow the definition of services. So this happens particularly in the service cases, which are so important to people with disabilities. Third, there was a push to require a complainant to show that stereotyping is a part of the prima facie case of discrimination. So to get through that prima facie case, they would have to show that there was a stereotype operating here. So let me just say how these things work out and why they're big knots, particularly for people with disabilities. And I'll start with comparative group. The push since Marin has been to require people with disabilities to compare themselves to other people with disabilities. Now, there are certain cases in which that works, right? For example, when you have a benefit scheme and certain groups have been, certain kinds of people with kinds of disabilities have been left out of that benefit scheme, it's a help to say, but just a minute, that other group with a different kind of disability is in. So we see this work, for example, in Gibbs, in Martin and Lasser, in Tranche-Montagne, where we have groups of people with disabilities, soft tissue, chronic pain, alcoholism and drug dependency, kinds of disabilities that have been treated as though they have something to do with malingering, moral turpitude, and they've been left out because of that. Well, in those cases, it works for the group to go forward and say, look, you know, we are left out of this benefit scheme because of the particular kind of disability. But it doesn't work when we're dealing with accommodation, because in accommodation cases, we're not talking about whether or not people are similarly situated. We're talking about whether or not a particular person with a particular kind of disability or a group with a particular kind of disability has not had the true characteristics of their disability taken into account. So, for example, there's a case where an employer discriminates against, in fact, fires a person who's got bipolar disorder. The employer tries to say, we didn't discriminate because there's no comparator, right? We don't have anybody to compare him to. We didn't treat him, differently. How can we compare him? So, there's no discrimination. So, in fact, it doesn't work in the accommodation cases at all because you're trying to get the service provider or the employer to take into account the characteristics of the particular person. Okay, I'm going to go really fast now. Services. This gets very connected to comparator group, right? So we see in Moore, for example, that Moore is told he can only compare himself to other children with disabilities. And therefore, the service that's an issue in Moore is simply special education. So he gets to compare himself to other kids who also need special education. Moore is dyslexic, as I'm sure you all know. He gets to compare himself to kids with other special needs. And if he's not treated worse than those other kids with special needs, there's no discrimination. So he's out. And the block that there is in making, first of all, defining the service here as special education, not general education, making the comparator group the other kids with special needs, means that essentially what we're saying is that as long as all the children with disabilities are being treated equally badly, there's no discrimination. So we're not thinking that, in fact, we should be changing the institution to include them, changing the rules, providing what's needed to get them to the same place. We're simply saying, oh, well, if we provide nothing, that's not discrimination. If we provide something that's inadequate for all children with disabilities, that's okay. The other problem that we have with the services is that we've got the Eldridge-Oughton distinction invading statutory human rights interpretation. So the Eldridge-Oughton distinction is either there's a service that's being provided and you're being discriminated against in a service that's already there, or there isn't a service that's already provided. And if it isn't a service that's already provided, you can't make a claim. So the push has also been to say, you're making a claim for something that isn't being provided. And so, there's no service there, so there's no discrimination. Again, this is an absolute wall for people with disabilities. What they're often looking for is something that is not already being provided. They need institutions to change. So we have to break that Oughton wall. The third point, of course, is about stereotyping, and I'm not going to go into that because we're going to come to that later in our discussion. But those are the real issues for us in the jurisprudence. The comparator group, the services issue, how they get connected and form a wall to, in fact, block inclusive change.
Thank you very much, Sheila, for this great overview of this paper that I very much commend to all of you. It provides a great history and great highlights of the challenges and of the concrete consequences of the types of arguments we make and the type of analysis we put forward. And all of those challenges were very much present in the recent case law, including the Moore case. And so that's what we will now turn to with Professor Malhotra, giving us an overview for the next 10 minutes on the Moore case and what it does and what it means.
Okay, so thank you very much. Bonjour. I'll just give a brief overview, especially for students here who are wondering what's going on and don't necessarily have the factual background. You think you'll get much more out of the discussion. I probably will leave more analytical comments for the discussion. This is going to be more factual, I think, in terms of what happened in Moore, so that everyone goes into the rest of the discussion with the same background, and I'll try to get through this as quickly as possible. Okay, so in Moore, the British Columbia Supreme Court, starting in the middle, because I think that's got to start somewhere. That's where I started. Quashed a human rights tribunal decision finding both systemic and individual discrimination in violation of Section 8 of the British Columbia Human Rights Code. Now, Section 8 of the code states, in part, that it is discriminatory if a person without a bona fide and reasonable justification denies to a person or class of persons any accommodation, service, or facility customarily available to the public on the basis of a prohibited ground. So Moore is not a charter case, okay, although there's certainly a lot of overlap, unfortunately, from bad charter decisions in the human rights area. And I think later on we can talk about some of that, although maybe someday they'll fix the Section 15 jurisprudence, and we're getting there, maybe, but maybe not. Okay, so after 43 days of hearings with respect to the budgetary constraints of the school district and special education policy in BC, the Human Rights Tribunal held that Jeffrey Moore, a child with dyslexia, was discriminated against because the school district and the ministry failed to provide him with sufficiently intensive supports early enough for him to prosper as a student. So that's a bare bones summary. If you want the original, it's over 1,000 paragraphs. It's one of the longest tribunal decisions I've ever read. So, but that's it in a nutshell. And so, dyslexia affects children of normal or above average intelligence areas such as reading, math, listening comprehension, and reading and oral expression. Early intervention and screening for children with learning disabilities and specific screening such as phonemic awareness training typically results in dramatically greater academic success. As a consequence of this failure, Jeffrey's parents enrolled him in a private school. The tribunal also found that students with learning disabilities were systematically discriminated against by a decision to disproportionately cut funding to services required to students with severe learning disabilities. So funding cuts due to financial difficulties resulted in the closure of a specialized program called DC-1 in the plaintiff's district, which offered intensive, remedial, and individualized instruction in a separate setting. The tribunal ordered individual and systemic remedies against both the school district and the ministry, including the cost of Jeffrey's tuition at a private school and $10,000 in damages for pain and suffering. The tribunal concluded that the school district's failure to consider alternatives when it closed the diagnostic center amounted to systemic discrimination, and it also concluded that the ministry engaged in systemic discrimination against students with learning disabilities because of what's known as the high incidence, low cost cap. There's a cap set for students with learning disabilities. Also, because of the underfunding of the district, the failure to ensure that services for students with learning disabilities were mandatory, and the failure to monitor the activities of the district. So the BC Supreme Court held that the tribunal erred because it mischaracterized the service customarily available to the public at issue in the case as education services rather than the provision of special education. So that refers back to this distinction of how do you compare people with disabilities. The court engaged in a detailed analysis of the Supreme Court charter jurisprudence that it felt would be of relevance in determining the scope of the human rights claim, and the court concluded that the plaintiff's claim was analogous to Auton, which is a case involving autism and ABA-IBI treatment, which is a special kind of treatment for children with autism. There, the claim failed, was found not to violate Section 15. So here, the BC Supreme Court finds the case is more analogous to Auton rather than Eldridge, which of course is the case that found Section 15 was violated when deaf patients were not provided with appropriate sign language interpretation. So in other words, Moore was not completely denied access to services for students with disabilities. The court found the claim was about the timing and quality of the specific services available to students with learning disabilities. Therefore, the service in question here was the provision of special education services, not education services. Okay, and if you find that puzzling, well, hang on. I mean, because, so the trial judge then found that the tribunal erred in ignoring comparative group analysis. The tribunal focused on whether Moore had been appropriately accommodated and not on engaging in comparative group analysis. So the tribunal had held in the alternative if a group analysis was absolutely mandatory, it would compare Moore's services with those received by able-bodied students, which, as I always thought, was sort of the point of equality law. The whole idea of equality was that you compare people with disabilities with able-bodied people. That was sort of the point of the Charter, I thought, and human rights codes. But the court, however, stressed the importance of a comparative group analysis. It concluded that the plaintiff simply failed to demonstrate that similarly situated students who require special education services were granted accommodations that the plaintiff was not. Furthermore, as an auton, the court placed emphasis on the fact that during the long course of the litigation, there simply was not much existing research on the best practices with respect to students with learning disabilities. The court did not consider international human rights law at all, even though Canada has been very much involved in international human rights law affecting people with disabilities. On appeal, the majority of the BC Court of Appeal upheld the Supreme Court in a short judgment. The majority finds that the trial judge correctly concluded that the service customarily available to the public was in fact special education. The majority also stressed that special education students such as Moore are not entitled to a service at a standard of perfection, but merely a conscientious and reasonable efforts to meet his needs. This is a very formalist decision. So the majority concluded that no further analysis was necessary, and it went on to conclude that the trial judge was correct in analyzing the comparative group as other students with disabilities who require services. In a lengthy dissent, Madam Justice Rules held that the case ought to be analogized to Eldridge rather than Auton. She reasoned that in light of the Ministry of Education's own policy manual, accommodations relating to reading were simply services that enabled students with dyslexia to participate in education programs generally. Excuse me. She noted correctly that having a narrow conception of the service makes it more difficult to demonstrate that a claimant experienced discrimination. She asserted that this is inconsistent with principles of substantive equality that undergird human rights law. She also found that Auton could be distinguished with respect to the issue of comparative groups because it involved access to public benefit schemes, where the accommodation is required to make the existing service entirely accessible to a person with a disability. She held that it was appropriate to compare people with disabilities with able-bodied people, which I think is logical. She went on to conclude that the tribunal had correctly determined the school district had discriminated against Moore by cutting specialized services that he required because of his dyslexia, and that this was in keeping with the vision of substantive equality that was required by Canadian human rights law. The fact that certain requested accommodations are novel in that they were not in effect in BC does not automatically defeat the claim, and she noted the enormous lengths the tribunal had gone to making its findings, which is 10,000 pages of evidence. And as I said, it's a lengthy decision. So she concludes that the tribunal was correct in concluding that the school district, given the findings of discrimination against Moore, also systematically discriminated against students with severe learning disabilities by disproportionately cutting services to existing and future learning disabled students to address physical priorities and closing the program. She found the keeping of the DC-1 program open would not constitute an undue hardship, notwithstanding the financial constraints faced by the school district school board, because the evidence demonstrated that at least one discretionary program was shielded from cuts, and the tribunal noted that no analysis of the impact of the closure on students with severe learning disabilities was undertaken. With respect to the liability of the ministry, Justice Rules upheld the tribunal's finding that both discrimination against Moore and systemic discrimination against students with learning disabilities occurred. Okay, quickly now, the Supreme Court of Canada thankfully allows the appeal unanimously in a judgment by Madam Justice Abella. She notes that the court, she focuses on the fact at the beginning that the preamble of the School Act of British Columbia states that all children are entitled to an education because a healthy democracy and economy requires their education. Special education, she concluded, is therefore not a luxury, but importantly is the wheelchair ramp that provides access to the statutory commitment made by British Columbia to all children. The court notes that the service in question was education, not special education, and comparing Jeffrey only to other students with disabilities risks perpetuating the same discriminatory structure. So here the court cites the paper by my learned colleagues Brodsky, Day, and Peters, who are here with us today. It's always nice to have the court validate your view, and so rather than focusing on comparative group analysis, the court holds that a claimant makes out a prima facie case by demonstrating that she or he has a characteristic protected from discrimination under the code, that they experienced an adverse impact with respect to the service, and that the characteristic was a factor in the adverse impact. So this much simpler test, which goes back to O'Malley, I think it's the rate test, once a prima facie case is established, the burden should then shift to the respondent, the service provider or employer, to justify the conduct. In this case, the court concluded that the tribunal was justified in concluding that Jeffrey required more intensive services than he received by the district. Furthermore, the district failed to consider the consequences of closing the DC-1 program and consider other accommodations. Therefore, the court found that the tribunal was justified in concluding the claimant had made out a prima facie case of discrimination. Furthermore, the court concluded the tribunal was correct in concluding the district had failed to demonstrate that it considered financial alternatives such as cutbacks in other areas. Therefore, the court restored the tribunal's finding of discrimination on the part of the district. However, with respect to the province, the court found that the actions which had negative effects were conducted by the district, and there's long technical reasons, I'm not going to get into this here, but they found the finding of discrimination vis-a-vis the province could not be upheld. With respect to remedies, the court upheld the individual remedies awarding damages to the Moores for their tuition costs, some of the transportation expenses incurred during trips to school, and $10,000 for hurt feelings and injury to self-respect. So at the end of this long odyssey, the court concluded that systemic remedies ordered by the tribunal were too remote from the claim. They said the tribunal is not a royal commission, so these include ordering the province to alter the manner in which it allocates money to students with service learning disabilities, the funding formula, establish mechanisms to ensure the province delivers students to learning disabilities in accordance with the legislative and policy goals, and provide a wide range of services, and to remain seized of the matter, very much the way that American courts have remained seized of matters in, say, racial desegregation cases of school busing. In these matters, the court concluded the province was entitled to structure its funding as it wished, so long as it complied with the code, and since Jeffrey had now completed high school, there was no need to remain seized of the case. However, by and large, the appeal was substantially allowed, and overall, it's a big victory for people with disabilities. And I'll leave it there and turn it over to the chair. Thank you.
Okay, thank you very much, Professor Malhotra, for this overview of the Moore decision. So we have now the table is set for our discussion. We have the paper from CCD that talks about the challenges in the case law pre-Moore. Now we have the Moore decision that touches upon some of those knots, or hopefully not Gordian knots, that you've identified in the paper. So I want to turn it now to Yvonne to ask the question, what now? Has the decision in Moore addressed the knots that you've identified, the comparator group issue, the services issue, and the stereotype issue? Mm-hmm.
Well, I'll touch on the first 2 points. And I think to a certain degree, yes, the answer is yes. I think the knots that Shelagh has referred to in her presentation, some of those knots, some of them, have started to be loosened. So that's a good thing. How have they been loosened? Well, I think you can probably guess, because you heard a very good overview from Professor Malhotra in terms of what was eventually decided by the court. But let me just really simply and quickly reiterate what some of those key loosening of the knots are. I want to make 3 points, and they're all really twisted together, but I'm going to pull them apart just for ease and make it very simple. As you've heard, Jeffrey required intensive remedial intervention in order for him to participate within general education. The question, as you heard, that was one of the big knots at the time of this case was, well, is it an Otten case, that is a special service that's separate and different and uniquely tied to disability, or is it an accommodation case, that is, we try to figure out a way to include people with disabilities into the service? You heard from Professor Malhotra what happened in the lower courts. They sided with Otten for some reason. And so what they did is said, in fact, what Jeffrey Moore was looking for was a special service that was somehow different. Now, the Council of Canadians with Disabilities, which is an organization I work with and for, was very concerned with this analysis because essentially what it was saying is, where it was pushing us is back to the dark old days of segregation, back to the dark old days of maybe separate, or at least separate and maybe equal, maybe not even equal, but certainly pushing us backwards. It also was pushing us backwards in terms of our approach to accommodation, which is not some sort of accommodation around the edges and tinkering. It is about full and substantive inclusion. So we sought intervention at the BC Court of Appeal and at the Supreme Court of Canada, and Gwen and myself and another colleague, Melina Buckley, had the opportunity to represent CCD at the Supreme Court. And I think we got some good results. In fact, in terms of how we approach, how do we define a service customarily available to the public, especially when we're talking about disability, I think we got some good answers. And what the Supreme Court said is, it's not about dividing it between general education and special education. Because when we do that, the court said, in fact, what we're doing is perpetuating disadvantage and prejudice, and it's a race to the bottom. So what the Supreme Court said is, no, this is clearly an accommodation case. So it's all about the service at issue is general education. Yay, yes, we agree. And what is needed, what Jeffrey required was a good old, this is very simple, good old-fashioned accommodation as the law has been set out in Muron and in Grismer. So I think that was sort of not number one was loosened is let's not go back to the days of special, unique, separate kinds of services for people with disabilities. Let's look at what's being offered, and then let's look at, can a person with a disability be accommodated? Now, one of the things that the lower courts did is they said, by choosing special education, then they said, and special education is there discrimination? Even if it's special education, is there discrimination? Well, how do we go about figuring that out? Well, we imply a comparator group analysis, which says, is Jeffrey being treated any worse than any other student with a disability receiving special education? And the lower court said, no, he's not. Now, again, the Supreme Court took issue with that and said that by introducing a comparator analysis, what we're doing is, again, perpetuating discrimination and in fact, promoting this separate but equal approach to the analysis of discrimination. And I quite like what the Supreme Court said. It said something to the effect of, that whole approach was majestically rejected in the Brown case. So I think they were pretty emphatic that, that kind of comparator analysis is no longer on, because I think the Brown case was decided, like years ago. So, 50 odd years ago, 60 years ago. So I think that was a pretty telling message and a pretty profound message. So what we have is accommodation. A comparator group analysis is not necessary. I think when you think about a comparator group analysis, though, when you're talking about accommodation, in the back of your mind, there is a comparison, and Professor Malhotra referred to it, is yes, of course, the comparison is with other students, regular students, what kind of benefit are they receiving, and is the benefit similar for students with learning disabilities? So, yes, there's a comparator that goes on, but it's not something that has to be resurrected each and every time and mechanically gone through. It's about accommodation. Can the students' needs be accommodated? A final point I'll make, and that is, when you undertake an accommodation analysis, one of the key things that the Muron case said and Grismer case said is, in order to establish that you've explored full accommodation, is you have to look at all alternatives to see how this accommodation can be made. And what the Supreme Court said about Moore is, one of the defenses raised by the school was economic necessity, economic choice. We had no choice. Our funds were cut. We had no choice. We had to cut. But what the Supreme Court said, no, you didn't. You didn't explore all the alternatives. You didn't look at what other options, were there other places that cuts could have been made? Were there other programs that were discretionary that you could have looked at? So my final message is, the other thing that Moore has taught us is where there are cutbacks, where there have to be cutbacks, you still have to apply a human rights analysis. So I'll leave it there.
Thank you, Yvonne. So some interesting signs, some interesting progression in Moore, and a major victory. And I think it highlights the role and contribution that interveners can have at the Supreme Court of Canada. There were a number of interveners, including yourselves, and very much your compelling submissions clearly had an impact. And I think when we hear the presentations here today, one of the things that Shelagh, I've heard as well when you were speaking is, what are the concrete impacts of a line of analysis? Because sometimes we're talking about these tests and comparator group and services and stereotype, and it can become legalistic and abstract and theoretical, but effective interventions in courts are when you can link it to, well, what will happen on the ground if you accept that test? What kind of incentives are we going to be giving? And I think that the pointing to the Brown case and the problematic impacts of using the special service as the test was highlighted. So some progress, but I'm now going to turn it to Gwen on perhaps some of the issues that were unanswered, unresolved by Moore. And I think you haven't spoken about the stereotype, Yvonne, so perhaps that's
Leave that to my colleague.
perhaps that's one of them.
Thanks, Philippe. I'm very happy to pick up on the stereotype question. The excitement of the duty to accommodate as delivered to us in Mioran, which Sheila talked about initially, and in Grismer, is that the duty to accommodate is about inclusion. And the positive duty, and I emphasize those words, positive duty of barrier removal. Those are really hard words to say together. Positive duty to remove barriers to inclusion and to build an inclusive society. Now, part of the pushback that we've been getting, that we see in the jurisprudence and in the dynamic of human rights legislation, is to make it increasingly difficult for complainants to get beyond the prima facie case stage of proving a case of discrimination. And that's, of course, really crucial in an accommodation case, because if the complainant can't get past that, then, and this is it's a legal procedural issue, evidentiary issue, the onus on the respondent of establishing that there wasn't an alternative to continuing with this discrimination or carrying on the discrimination. There wasn't i.e., there wasn't an adjustment, that is, an accommodation that could have been made to eliminate or diminish the discriminatory impact of the challenged practice or rule. So you have to be able to get beyond that prima facie case stage. And there are a number of things that are these days, one sees it in the cases, routinely thrown at complainant counsel, sadly often by governments on the other side of the cases that are about discrimination in services, that are designed, that are calculated to cut the complainant off at the pass so that there's no prima facie case of discrimination being made out. Therefore, we don't even need to ask whether there was something positive in the way of an adjustment, an accommodation, I'm using those terms interchangeably, that the respondent might have made. Now, having said that, the issue of, and stereotype is one of those. Okay, so back to stereotype. So it gets argued by respondent side counsel. Well, there isn't any proof that there was an underlying stereotype, and that's part of what the complainant has to prove to get beyond prima facie case. That said, by me, the problem of making stereotype part of the definition of discrimination is way deeper than the prima facie case issue. I say that it is to make stereotyping an essential element of discrimination goes much deeper than burden of proof because it is grounded in an insufficient definition of discrimination. There are going to be cases, not all, but many, in which it's just not possible to establish that stereotype. It's either so far removed from judicial consciousness or mainstream consciousness that you won't be able to get there, or, I mean, there really just isn't one. Because the definition of stereotype, and this is, I'm making what I think is a hard point, because it's very embedded in us as Western thinkers about about discrimination, that the essence is somehow stereotyping. Why? Because it often works for us. When you have an individual who wants to differentiate themselves from a negative judgment about a group, it's about stereotype. There are lots of disability cases that are that. Individuals get denied opportunities to advance because they've been judged by a group stereotype. But that's not the whole picture. There is, and accommodation cases are often not about that. Think definition of stereotype, and you'll see, and I think it will become clear how limiting the imposition of this requirement that the complainant prove stereotyping at any stage of the litigation is. Stereotyping, and this is clear from the cases, including most recently Eric and Lola out of the Supreme Court of Canada, the definition of stereotyping is a false generalization about the group. Now, where is that in the Moore case? What's the false generalization about Jeffrey Moore? We could say he's been treated as though he's less worthy, but what's the false generalization? The government argued repeatedly that his case should not succeed because there was no, it couldn't be shown that there was this stereotype, false generalization operating. Case would have lost had there been an insistence on proof of stereotyping. That was successful in Mioran at early levels of court, back in the days of Mioran. The courts couldn't see that there was an underlying false generalization of the group, about the group. No, the issue is not, in many accommodation cases, false generalization of the group. It is that a standard has been constructed simply without taking the whole of the society or the group eligible for the benefit into account. Public school education has been structured without taking the needs of dyslexic students into account. Neutral on its face, no underlying stereotype. In order to succeed in an accommodation case, like Moore, you need a different understanding of discrimination and how it works. In particular, you need something that supposedly is well established in Canadian law, but persistently resisted, particularly by governments in human rights litigation. And that is the understanding of discrimination as sometimes manifest through adverse effects. It's not the facial differential treatment grounded in stereotype, which works sometimes. But most accommodation cases are about something else today in North America. They are cases of neutral appearing rules. Nobody can trace to an underlying stereotype. Prejudice is often also used as an equivalent of stereotype when these things are talked about. But nobody can trace it to that. And the model of discrimination as direct, overt, intentional, that's an early model of discrimination, grounded in stereotype or prejudice, oftentimes isn't relevant. And if assumed to be the only model of discrimination, will result in defeat of most accommodation claims, and essentially gut what the exciting potential and right accommodation is really all about, reducing it to blatant bigotry and draining it of its positive component, and or positive core. And final point on stereotyping is that it, as I say, it's so closely connected to an understanding of discrimination as overt differential treatment. It's an act that has to be restrained, stopped. The problem of that is, rather than something needs to be changed, altered to make the institution inclusive, is that it leads you to a deficient sense of remedies. You either don't get to the point of being able to prove your claim, or if you do, you're still not entitled to an effective remedy. Why? Think. What would be an antidote to an inaccurate group differential treatment based on an inaccurate group generalization? The antidote, the remedial antidote to that is stop the differential treatment. And I'm way out of the question of comparator group, because this is so deadly. It can work. It can defeat a claim no matter how you run the comparison. If your only entitlement is avoidance, that differential treatment based on stereotype must be avoided. Once it's identified, the remedial answer is same treatment. Treat everybody the same. And that, of course, doesn't help Jeffrey Moore either. That's exactly what he got. Same treatment as both the other kids with disabilities whose programs were being cut in a time of cuts. And he was treated the same as other kids in the public school he attended. It just didn't work for him because of the differential effects. So that actually, I finish with that point, saying that actually implicitly it is countered by Moore. Explicitly it's not. And then when we come to the more recent case of Eric and Lola, we see that's something which is the case about the common law spouses out of Quebec. The court is very, very much struggling with that. There's a 5-4 split there, right on the question of stereotyping, and with 4 of them saying very clearly, "Oh yeah, you've got to prove it," and she didn't. And so it's a haunting feature of our jurisprudence, and it's a real problem, really serious problem. Not finally resolved by Moore. I know I have to turn it over, but significantly helped by us we are significantly helped when we get to Eric and Lola, because Justice Abella says clearly there for 4 of the judges, and 4 of the judges at least, that for 4 of the judges, that's what she's done, that no, it's not a requirement. So I know I answered an unasked question, but that's what I have to say.
No, thank you. And I actually wanted to jump in, because if you think that Gwen is persuasive and right when she's talking about human rights law, the majority in Eric and Lola agrees. The majority finds indeed that stereotyping It's a narrow majority, but it is a majority nonetheless, and it finds that it is not a requirement. I just want to briefly read what it says because I think you'll see that that Gwen has it right. It says, attitudes of prejudice and stereotyping can undoubtedly lead to discriminatory conduct, and discriminatory conduct in turn can reinforce these negative attitudes. But the case law should not be seen as establishing an additional requirement on claimants to prove that a distinction will perpetuate stereotypical attitudes towards them. Such an approach improperly focuses attention on whether a discriminatory attitude exists, not a discriminatory impact, contrary to the case law. It is the discriminatory conduct that the law seeks to prevent, not the underlying attitude or motives. And it goes on to say that requiring claimants to prove this stereotypical or negative attitude about them imposes a largely irrelevant, not to mention ineffable burden. So I think very much on point to what Gwen is saying, but the fact that it is such a narrow majority shows that issue is still a live one, and so thank you for highlighting it. Another element of more that has been the subject of discussion is the issue of remedies. There were requests for systemic remedies in Moore, and the Supreme Court did not uphold those, and so I'll ask Sheila to address that issue, please.
Well, in addition to the good news about Moore, there's also some bad news. So there are two things that are connected that the court has done in Moore that we're now concerned about, and it has to do with this issue of remedies. First of all, the Supreme Court of Canada has let the province off the hook. So they've rested the whole of the liability on the school district. The province, however, is the funder of the school district, right? It is the statutory authority for education in the province. It sets the standards. It issues the policy books, right? It sets the guidelines for education for the whole of the province. Now, the part of the background of this is that the district was struggling with some really very, very serious funding issues. So one of the funding issues is that the province had actually put a cap on what they call low incidence, high something.
High incidence, low cost.
High incidence, low incidence, high cost. Low incidence, high cost. They put a cap on the number of students that could be identified in any district as being in this particular category. So you could have, 75 kids with severe dyslexia, but you were only allowed to identify 25, let's say, for your district. So the province itself was actually arbitrarily restricting the amount of funding that there could be for the special education for these kids. In addition to that, there was a general problem about underfunding for the school districts. In addition to that, there were, as I say, all these policy issues about who was actually setting the standards and requiring the districts to do, etc. The Supreme Court has let the province off the hook completely, saying that the district made discriminatory choices inside its own budget, right? It could have made different choices inside its own budget, right? Even though it had all these cuts and restrictions on it and so on, it still didn't consider, what the alternatives were to cutting the diagnostic center. And therefore it rests the whole of the responsibility on the shoulders of the district. Now, I think that's just wrong. Just wrong. If we're looking forward to accommodation, how it really needs to work, what the responsibilities of governments are, this is not the way to look forward to actually getting it into place. So it's simply wrong. The rationale that Justice Abella gives us for this is she gives us a little speech about the difference between individual and systemic discrimination. Also very important, I think, to all of us. She says the reason why she's not going to go with the liability on the province is because the systemic remedies against the province are actually too remote from Jeffrey's individual case. The systemic remedies are too remote from the individual case. We have to make the remedies fit, what we have started from. We've started from Jeffrey's case. That, of course, individual cases have systemic implications. We all know that, so we shouldn't make a distinction between individual and systemic. But she goes on to do that very thing, in my view, and consequently says we can't get to these remedies because it has to fit the individual evidence that there is about Jeffrey. And so there's a real, the reasoning about individual and systemic is also really troubling, I think, because we have had the experience. We're trying to figure out how to deal with systemic discrimination, aren't we? And we've had the experience of, for example, the Canadian Bar Association going forward to try to stand for the proposition that legal aid is inadequate and that consequently it discriminates against women and poor people and a number of other groups who are affected by this very inadequate legal aid system. We've been told by the courts that the Canadian Bar Association can't go forward with that case because we need an individual. Here we have an individual, but we can't get to the systemic remedy. So we're sort of we're in this spot, I think, in Canadian litigation, trying to figure out how we do this, right? Which way around does the court really want it? We come forward with a very, very strong individual case like Jeffrey Moore's. We can't get to the province, to those systemic remedies that we really need. The district gets left with it. It really puts us in the position of having parents in British Columbia, and I think across the country, think to themselves, okay, it's good. It says the right thing. It says that our children are entitled to education like all children are. But it still puts us in the position of having to fight this out district by district, right? And so I think that's a real bottom line question for us in where the courts come down. I think that Gwen may have some things to say about that.
Gwen, did you want to add something? Yeah.
Yeah, I think I find it particularly troubling that neither level of government, neither the district nor the province, is held responsible for monitoring the effectiveness of service delivery to students with disabilities. I just can't see why that would be too onerous a thing to ask when the provincial, in BC certainly, the provincial government has express statutory powers to monitor and to enforce school board non-compliance with standards that have to do with quality of education for the province as a whole. And it just seems to me that the court has forgotten its own and very important insights in the Robichaud case, to the effect that, which was a case about sexual harassment, it established the proposition that employers are responsible for sexual harassment perpetrated in their workforces. And I'm paraphrasing now, but the basic idea is, the employer's got the power to fix it. Human rights legislation is remedial, preventative. We look to parties that have the ability to give effect to that prevention and remediation. In this case, it's clear that the province has the deep pockets. It has the authority, the funding, all the powers necessary to ensure effective service delivery by the districts on a province-wide basis for students with learning disabilities. So I just don't understand. I just don't have an explanation for what for the big gap that there is between Robichaud and the remedial principles and the remedies granted there, and the hostility to systemic remedy and senior level of government liability in this case.
Perhaps a question for the panelists on that, because I think the Supreme Court is often case law is trying to create good incentives for good behavior. And that's why in Robichaud, one of the reasons the court said we need to hold the employer accountable, it's because the employer has the power to fix it, and we want the employer to have an incentive to fix the situation and not say, well, that was an employee and the employee wasn't doing his or her job while doing the harassment. It seems that in Moore, the court is saying, well, the district really had some options that it didn't consider, even within the reduced budget that it had. My question is, do you think the outcome would be different in a case where, on the facts, you had a district or you had an organization that had looked at all options and had then said, we can't do it without more money, and had gone expressly to the province and said, we need more money, we've ruled out all of the options, and that the province then said no? Is the door open for a situation like this after Moore, you think?
Yes, I do think the Moore definitely opens the door to that by indicating where the funding itself is discriminatory. That's a different case. And we have some cases in the courts currently that are about the role of government as funder. And one is a case, I mean, Philippe won't be able to talk about this, I shouldn't think, but it is the challenge in the Aboriginal child welfare case to the federal government's practice of providing less funding for welfare for on-reserve children, including services that are preventative in nature, intended to help children having to be removed from their families, less funding than that provided to children living off reserve, generally delivered through provincial governments. But we have the federal government having acknowledged that they want to meet the standard for across the country, but then providing significantly less to on-reserve children. And there we have a case that's different from Moore, because it is a straight-up allegation of discrimination, race discrimination, discrimination against Aboriginal children and their families and communities by the federal government in the provision of this targeted program. And so I think the government's in real trouble because of what the court has said in Moore. But frankly, I'll just take the opportunity to say I have a problem with what the government is arguing in cases like this. And they're different governments, but it's right across the country. Federal and provincial governments making arguments that effectively are designed to ensure that human rights legislation just doesn't stick to them. And I think governments need to take a good hard look at that, because that's a real I'm going to say that's a breach of the public trust. The trust that the public should legitimately be able to have that when governments enact human rights legislation, sign on to human rights treaties internationally, committing themselves to providing effective remedies and avenues of recourse within the domestic legal system for breaches of equality rights. When they do all of that, and they're governed by the Vienna Convention, that says that requires state parties to treaties to perform their commitments in good faith and not to do things that undermine the purpose of the treaties they've signed on to. When they do all of that, it's a real, I think it's very corrosive to the public trust that's been placed in governments, and it's just not appropriate that they should behave as though they can say, one thing in policy settings and when reporting to international human rights bodies, i.e., and they say this, we have human rights legislation as a primary means of giving effect to the international human rights obligations, we've assumed Canadians can obtain redress and remedies either by the charter route or through human rights legislation. They say that. And then within the domestic legal forum, they make these procedural, formalistic moves about services, funding doesn't count as a service, narrow the definition of service, etc. There's something very wrong here that calls into which itself calls into question the compliance of government with its human rights obligations.
Thank you very much. As you can see, there's lots of issues, lots of public policy and legal overlap. At this stage, I'd like to open it up to all of you to ask questions to our panel. We have about 10 minutes left. I know that there's a class, I think, at 1 o'clock. So those of you who need to leave, by all means do so. But there's some time for questions for our panelists. And in French or English, if need be, je pourrais les traduire si c'est en français.
I have a question. I'd like to go back to the issue of stereotyping. I thought that was a really interesting discussion, but I'm wondering maybe is the requirement, I understand that the requirement of proving stereotype in the analysis is very problematic, but I'm wondering if it's not the application of the analysis of stereotype and prejudice that's more problematic than maybe the words themselves, because just going back to the definitions of stereotype as a false generalization of a group, or prejudice as the preconceived notions that we have, or preconceived opinions that we have of groups of people. And if we think back historically of how persons with disabilities have been treated, and sort of the notions of able-bodied persons saying we are better than persons with disabilities, therefore, based on these preconceived notions, we will tell you what's good for you and tell you what to do. And so I'm wondering maybe if it's not the words that are problematic, but more so the court's application of the words, if that makes any sense.
Well, I'll start, and my colleagues can jump in. I mean, I think you raise a good point, and in fact, to some degree, stereotyping is a huge problem for people with disabilities. I mean, its negative attitude is enormous, and that's just something that never goes away. And that might be kind of when the courts apply that term stereotyping, thinking that they're really dealing with the fundamental problem, that barrier that confronts persons with disabilities. I think what the court hasn't figured out, I mean, sometimes they say, the right words and then they forget them. But, I think the court has talked about the social construction of disability, particularly in Eldridge and in the Via Rail case, where they say it's not so much about attitudes, but about the way that society is structured. And Eaton talks about this as well, that it's the way that we structure society based on, if you will, able-bodied norms, instead of looking at, as Miron suggests, a more inclusive strategy that really embraces difference as being normal. And I think the court gets itself twisted up with, and maybe put your finger on it. The terms it may think it's doing the right thing. In terms of stereotyping, I guess, when it comes to disability, but it's not the complete answer. So, maybe there's some confusion. I mean, these just continue to be knots that have to be unraveled for sure.
Slightly tangential, but I think is a point worth making is the question of law as a tool for social transformation, something I spend a lot of time thinking about, because I think at some point, whatever point you take in terms of the doctrinal question, you also have to think about the very, very big picture of changing attitudes. And so going back to some of Yvonne's point, and I think law, the kind of thing, doctrinal question you're talking about is important, but sometimes you got to go beyond that. And I think that speaks to the point about building social movements and also changing changing the actual discourse on the ground. I have an op-ed in today's Toronto Star in the online version about mandatory carriage of disability channels. It may seem tangential, but I don't think it is, because I think if you bring in specialty channels, feature people with disabilities, you can actually change some of the bullying that goes on in classrooms with people with disabilities. And I think those kinds of things are just as much a part of the picture. You certainly need the legal tools, you need the legal doctrinal tools, but I think some of these big picture things will have some kind of effect, I believe, in changing attitudes, changing the narratives of people with disabilities. Put it that way.
I'd just like to add, I think that perhaps the notion of discrimination as stereotypes is one that in a way brings us back to the early stages of, well, you're fighting intolerance, you're fighting discriminatory attitudes. So to be sure, you need to fight that and you need to prohibit that. But there's been a lot of evolution, and if we look at the title of today's panel, we're talking about the word not tolerance, but we're talking about inclusion. And I think if we look at discrimination as a lack of inclusion, then the concept of stereotype becomes less helpful, because it's too narrow. If you're talking about having a society that's inclusive, it doesn't matter the reason why society is putting barriers. You need to remove those barriers. And I think that Mayoran has moved towards that, moving from the fact where it used to be that, well, you just keep the rule there, but you'll do an accommodation and one-off, but you're keeping this rule that's not inclusive, to saying, no, you have to look at the rule. And you have to look at the effect of the rule, not just the purpose, and not whether it's based on stereotypes, but is it preventing full participation of individuals in society? And we've seen that in international law with the Convention on the Rights of Persons with Disability, that again, it's not about tolerance or charity, it's about full inclusion, and the intent is not necessary. So that's some of the problem, I think, with stereotype, is that it gets you to that narrower view of discrimination. Any other questions? Yes.
Thank you so much. That was just, I couldn't think of a better way to talk about this case and its implications. That was just fantastic. I want to come back to where the case falls short a little bit, because I think that there are other ways other than just this stereotyping issue. You know, we always talk about how bad cases make bad law, and I think sometimes really easy cases or good cases make inconsequential or weak law. And this might be one of those cases, because you have a perfect storm of evidence in support of Jeffrey's case, right? You have a type of disability where you can actually measure the impact of the accommodation and show that it would have made a difference. You have evidence that the board didn't actually consider alternatives to closing the process and actually wrote that in their minutes. You have evidence that there was a complete failure to consider any other alternatives other than closing it. So you have this kind of perfect storm of evidence showing the discriminatory impact, which may, in my view, lead to a lot of distinguishing of this case when we get to more complicated cases about disabilities where the impact is not as measurable, with behavioral issues or different types of mental disability, where there is consideration of some alternatives but not all alternatives, where there isn't a complete elimination of the program but rather a severe reduction. And so I wondered if you wanted to, or if you could talk, or if you've considered how do we build on this case, given that it is kind of a perfect fact scenario, and is that going to limit where we go from this? And I guess the other consideration there is that Justice Abella specifically identified the fact that the notion of the role of education in the province was discussed in the statute and in the policy guidelines of the province, so that she didn't have to talk about the role of education more broadly. She could just say, oh, well, this is what the statute and the guidelines have said, so they should apply this. So it's really kind of this perfect storm. I wonder what your thoughts are about that.
really excellent comments. I'll just take a quick slice at possible political, and I agree with them all. I can well imagine the government amending the Education Act so that the purpose clause is get rid of it, or so it's not so inclusive. I saw them do that in BC with legal aid legislation, so nobody could hang their hat on that. Don't have an admin law argument, or because it actually is more an admin law thing than a human rights thing. It's a bit, I don't know. One can worry about. I'm going to worry a bit about political response out loud. I think I think that it would be good if more progressive trustees across the country started holding conferences and meetings to strategize about how they're going to go to provincial governments and make some demands, have some negotiations about how better agreements and structures and monitoring mechanisms can be put in place so that the districts are better equipped to respond to those and detect the individual requests as they come along. I think some districts actually are very sophisticated in their ability to detect and respond, but when there's when they're hampered by lack of funding, they need a way to be able to take that up quickly with the province. And it's simply not right that more families like the Moore should have to come along and spend more than a decade in the courts fighting. That shouldn't be. That there's individual assessment of individual students' needs. Well, that's right, of course, and all school districts understand that. But the funding issues really are kind of big issues for big bureaucracies, and there need to be appropriate mechanisms in place so that when cuts are being made or budgets are being considered at all, human rights considerations are fully integrated.
Can I just add?
Just very briefly.
Very. I because I think you raise a really good point. I think the cases, including Moore on disability, they've been a lot about access. And I think because of the facts have been easily understood by the court, and you say the perfect storm, I think this is by no means that we're out of the woods, because I think there are harder cases out there where people with disabilities actually need specific, unique services that will enable them to participate fully in society that maybe you can't attach to a general service, but is more of a unique service. I think those are the harder cases. We haven't seen many of them, but hopefully this puts us a step on the road. But yeah, there's some bigger fights out there.
Thank you. So you're leaving us with the very intriguing question of whether good facts can make bad law as well. So we have to wrap it up on that, but thank you very much to all the panelists and to all of you for your interest and participation. And we look forward to continuing working on those important issues. Merci.